Uh, Welcome to the May 12, 2021 monthly meeting of the Lancaster Mennonite contingent of 1040 for Peace. It's great that we can meet together in this way via Zoom. 1040 for Peace is an organization that promotes a national movement to encourage U.S. taxpayers to express their opposition to U.S. military spending and imperialism when they file their federal income tax returns. That is Form 1040 each year. I'm H.A. Penner. I'm the convener of the group here in Lancaster. We support the Religious Freedom Peace Tax Fund legislation that seeks to protect the rights of all of us as envisioned in the Bill of Rights of the United States Constitution. We're also an affiliate. 1040 for Peace is also an affiliate of the National War Tax Resistance Coordinating Committee, a coalition of individuals as well as local, regional, and national groups that support those who refuse to pay for war. NUTREC, as we call it, promotes nonviolent strategies for social change via the redirection of tax dollars toward programs of justice and peace building. Today, we're delighted that Attorney Peter Goldberger has zoomed in to be with us. Peter is one of those persons whose reputation precedes him. I suspect most of us heard about Peter before we met him. That's true for me. He traveled to Lancaster to speak at the Friends Meeting House in the spring of 2014. At least that's what Titus Beachy tells me. Titus hosted him at that time, and his involvement with us then in Lancaster made me anticipate his November 8, 2014 presentation on what does the Supreme Court's Hobby Lobby decision mean for war tax resistors. That presentation was given at the NUTREC gathering at the Earlham School of Religion in Richmond, Indiana. And I'll never forget Peter's role in my wife's and my dealing with the Internal Revenue Service regarding a frivolous letter that we received from the IRS some months ago. Peter's a graduate of Haverford College and Yale Law School. He's been a criminal defense lawyer specializing in appeals and Supreme Court petitions for more than 35 years. And for over 30 years of that time, Peter has been a volunteer legal advisor to NUTREC and to the Philadelphia Yearly Meeting on conscientious tax resistance issues. Peter, we're glad that you are with us today via Zoom to address conscientious tax objection as a matter of religious freedom. What is the legal landscape? Welcome.
Thank you, and good to see you again, H.A. And I want to say hello and particularly call to folks' attention that from the Lancaster group that we have Lincoln Rice joining us today, who's the national coordinator of NUTREC from Wisconsin. So if there are questions that are outside of my domain, which I try to stay narrowly in the legal realm, Lincoln is the expert on the larger picture. So I'm really glad he's here today, and I see some very old friends, Titus and others I'm very glad to see. So I'm wondering, I would be curious to know how many of you were in attendance in 2014 when I was in Lancaster and gave a talk at that time. Not that many. Okay, that's good. So, so we have about 5 of the 20 or so folks that are on the live presentation today. So I won't assume that you remember any of that, even if you were there. But I did give a kind of a first draft of my big talk at Richmond to the group in Lancaster a few months before. And at that time, I organized it around some vocabulary and explanations of the vocabulary, tried to explain what we mean by conscientious objection in the legal world, and civil disobedience and how that's different, what the free exercise of religion is as understood by the Supreme Court under the First Amendment, and then the statutory protection that Congress enacted for freedom of religion against federal government programs in the law called the Religious Freedom Restoration Act, RFRA, which I may refer to casually as RFRA. And those were the concepts that I then developed in a longer talk at the Earlham School of Religion, which, if I remember right, may have lasted an hour and a half, which I'm certainly not going to do this morning, developing all of those concepts as they relate to war tax resistance and to one another, and what the relevance and importance of the differences might be. But today I'm just going to give a little quick recap and overview of the statutory and constitutional protections as they exist today, because actually there has been in the last year seemingly a very important development on the constitutional law front, having to do, I think, with the changing membership of the Supreme Court in the last couple of years. 3 new justices in the last 4 years. And so let me just do a little high school civics on this subject first, just to remind you that the Constitution sets a baseline of protections and rights, and that even though most of our rights and obligations are set by law passed by Congress, the Constitution is a limitation on what Congress can do. So there are some things that people are entitled to do, and that regardless of what Congress may wish to enact. And one of those is very fundamentally the First Amendment, that says literally, Congress shall make no law respecting an establishment of religion or the free exercise thereof, or abridging the freedom of speech and so forth. And so we talk about the freedom of religion, but literally the First Amendment is written in terms of what Congress can do. And for most of our history, of our constitutional history, the Supreme Court has interpreted the free exercise of a religion clause very narrowly. And I discussed at some length in my longer talk how this view originated in the 1870s as the federal government was dealing with the Mormons in Utah and their insistence on that polygamy was authorized or even mandated by their religion, which is illegal in almost every civilized legal system. And the Supreme Court created this rule that while the First Amendment entitles you to believe anything you want, it certainly doesn't entitle you to act in any way you want. If it did, we couldn't have a system of law at all. And that I'm not endorsing or agreeing with that or disagreeing with it, but I'm just saying that's the foundation of the constitutional law of free exercise of religion for 150 years since then. And that view reached its a height in 1982, 100 years later, when Congress said that Oregon could fire a Native American drug counselor because he used peyote in his religious exercise. And there was an upsurge of resistance against that decision, called the Smith decision, that resulted in the enactment of the Religious Freedom Restoration Act, where Congress quite unusually said to the Supreme Court, we're going to pass a law requiring all federal programs and federal agencies and federal laws to be interpreted to require an exception for people who disagree and can't comply on grounds of sincere religious belief and exercise of their religions. And that was called the Religious Freedom Restoration Act. And like all laws, it's subject to court interpretation, how strictly it will be enforced and under what circumstances. But so that law came again before the Supreme Court in 2014 in the Hobby Lobby Conestoga Wood Products decision involving, we call it the Hobby Lobby decision, but it was also involving the Conestoga Wood Products company, a Mennonite company from Lancaster area, whose owners said that they couldn't comply with the part of the Obamacare health insurance, health reform program that required all employers to provide contraceptive assistance at no extra cost to their female employees. And the Supreme Court said that RFRA required an exception for those who were sincere religious objectors, even if their objection was scientifically unfounded, as long as it was religiously sincere, and even if it was based on a rather attenuated idea of complicity. That is, no one was being required to use birth control against their beliefs. No one was required to administer birth control against their beliefs. No one was required to pay for birth control for anybody else against their beliefs, only to have an insurance program that included this no extra cost benefit provided by the insurance company. But the Supreme Court said, nonetheless, if the religious belief was against complicity, which is a pretty common principle in religions, that the government had to fashion an exception. Now, you would think by analogy that that would be an enormous breakthrough and precedent for war tax resistors. But the Supreme Court made a point in the decision of saying, well, that doesn't mean, of course, that if you object to paying taxes on religious grounds, that you could have an exception, because that would be impossible for the government to function or administer. And it was the only situation that the court went out of their way to comment on that was not presented by the facts of the case. That's not unusual that the court has given war tax resistance as an example, counterexample of protection for religious freedom when in cases where that has come up, because I mean, that example was given and quoted in Hobby Lobby from a decision in the 1930s of some students at the University of California objecting on religious grounds to being required to participate in the ROTC program, the Reserve Officers Training Program in college. It was given again as a counterexample, as an example in the Amish Social Security exemption case in the 80s. It's always been sort of the extreme, ridiculous case that the Supreme Court has held up as not protected by whatever they were saying when they were otherwise protecting freedom of religion. And it's based on an analytical structure for free exercise cases, as I say, going back to the Mormons, where the Supreme Court has said that as long that we don't have to, that a law doesn't have to allow a provision for conscientious objectors, as long as religion is treated equally with other secular, equivalent secular objections. And if religion is treated worse, on the other hand, a kind of discrimination against religion or a targeting of religion, then the law might be invalid. So they struck down a law like that, for example, that involved animal sacrifice by a voodoo kind of religion in Florida. That law was invalidated because it was targeted at animal sacrifice and not at humane treatment of animals in general. But now what's interesting in the last year is, and which causes me to have something new to say, is the decisions that have gone to the Supreme Court between, and this is just between November of 2020 and April of 2021. So this is a very new development. Challenges to the COVID-19 restrictions imposed by governors in various states, brought by religious groups. So for example, in November, the Catholic Church and the Orthodox Jews in New York City objected to the limitation of only 25 people, if I remember right, being able to gather indoors for an event in New York. And they said that was in effect targeted at the Orthodox Jews who were defying the restrictions in New York and adversely affecting the Catholics' ability to hold Mass in their larger churches. And their claim was that, well, more than 25 people can gather at a time in a retail store in the mall. And so why can't we gather for religious services? Now you would expect under the prior precedent that claim would lose, because more than 25 people sitting down for an hour right next to each other and talking or praying and singing out loud doesn't pose the same risks of transmission of COVID-19 as a crowd of people moving in a big box store for 15 or 20 minutes, none of them necessarily right next to each other, and probably wearing masks. But the Supreme Court struck down the restriction in New York, saying that taking a much broader view of what's comparable than you would have expected them to say. And this was a 5-4 vote, depending entirely on the votes of the new members of the Supreme Court. So the dissenters being the 3 moderate to liberal justices, plus Chief Justice Roberts, and the majority that struck down the restriction being the 5 even more conservative members of the Supreme Court. And this trend, there were 4 or 5 such cases. They were all decided rather summarily, without full briefing or argument, just on the presentation of emergency motions at the Supreme Court by the church groups. And it culminated in April in a case from California where a religious group challenged the restriction that California had imposed on members of more than 3 households gathering indoors, even in a private home at one time, saying that this prevented the Bible study groups that they wanted to hold from gathering. And again, you might have thought under the pre-2020 doctrine that all the court would have had to say is, look, more than 3 households can't gather in one home to watch the Super Bowl, then it's perfectly lawful to say that 3 households can't gather in one home to pray. That's directly comparable, and religion's being treated equally with everything else, therefore it's not illegal. But the Supreme Court struck down that restriction. And what they said was that it was well settled, and it's certainly not well settled, or it hadn't been well settled before November, but the Supreme Court said, as if, and when they say it, that makes it the law, it was well settled that restrictions that affect religion have to be at least as generous as the most generous restrictions imposed on comparable, not identical, but comparable secular activities. And again, they cited the retail shopping as comparable to religious, a prayer group in a private home. The dissenters saying this is ridiculous and illogical and untrue, and but that's the dissent. So if that's going to be the law, and if they're actually going to apply it as a precedent in an honest way, which you never know, it certainly causes me to reopen my thinking about arguments that we can make for tax resistors by asking, and just I'll give a couple of quick examples and we can open up for discussion and questions. One is particularly about penalties. Most tax penalties, lateness, negligence, so forth and so on, understatement of income, have exceptions for so-called reasonable cause or exigent circumstances. Your records were lost in a fire and you couldn't file your return on time, or there was, you had to attend a family funeral and you couldn't make the deadline of filing or something like that. I think it's pretty clear under this, if these recent decisions are taken seriously and enforced, that a religious objection would have to be treated as being at least equal to ordinary reasonable cause or compelling circumstances that prevent a person from complying with the tax obligation in the conventional way or at the conventional time. As to the payment of the tax itself, if shopping at a big box store is comparable to praying in a private home, then it's hard to see why any exemption from having to pay tax, like not having sufficient income or being a non-citizen who pays taxes to another country but has income in the United States, or having income from a tax-exempt source as defined by a statute, can't be said to be comparable in that same very loosey-goosey way to having a religious objection to paying, particularly where the person, and this is my final point, particularly if the person says, if there were a religious peace tax fund law in place or something like it, I would fully pay, because then the government has a way of getting the same amount of money, notwithstanding the objection to complying with the ordinary rules. So since what's comparable is what we mean is comparable in relation to the important governmental purpose that the law is designed to serve. And so if the objector's objection doesn't impair the important governmental purpose any more than the non-religious person that doesn't comply for whatever reason, then the religious person, we would think, would have to be treated the same. So this is a very new development. It hasn't been widely applied to other circumstances, but it causes me to, reopen my thinking. And you may remember that when I talked in Lancaster, when I talked in Earlham about this, I brushed off the free exercise challenge as being ridiculous and impossible because of the precedent that so well established, and that the tax law is not targeted at religious people. But I'd have to reconsider what I said based on these new decisions if they are really establishing a new doctrine. Okay, so let me stop there and see what thoughts people have and questions you have. HA, how do you want to?
Okay, questions for clarification, and or we can take it in a direction that Peter has suggested. What are your questions?
So, Peter, what would be the path for getting this question in front of the Supreme Court again?
Right. So war tax resistance has not been an issue in any case before the Supreme Court of the United States, other than in this dictum, as I mentioned, when it's brushed aside as it used as a ridiculous counterexample to something. But as a case, it's a war tax resistance case hasn't been before the Supreme Court since 1974. And that was the American Friends Service Committee case, where the Quakers were saying our religion prevents us from participating in the withholding of tax from the income, from the paychecks of employees who are conscientious war tax resistors. We are required by our religion, said the Quakers, to assist them in their resistance by not holding, not forwarding the tax part of their paychecks to the government. And they brought a lawsuit and won in the district court in Philadelphia, and that was appealed to the Supreme Court by the government. And the government prevailed on the basis of a law called the Tax Anti-Injunction Act, which prohibits you from challenging a tax law affirmatively. Basically, you can challenge the application of a tax to you or a tax law to you only as a defense if the government comes after you. So that law stands, and I think that precedent stands. So the answer to your question, Titus, is that someone who is being penalized or prosecuted, which is very rare with tax resistors, or in collection activities, could theoretically raise this argument or something like it in their defense and have it adjudicated that way. So you don't have the control of picking your test case exactly necessarily, or but you don't have the burden either of creating the case and bringing the case to court. They come after you and you raise this as a defense, and then that's how it comes up.
Peter, have you seen some of these cases coming forward where you think that maybe there would be a defense from what the action that was taken by the Internal Revenue Service against a taxpayer who was refusing to pay because of war?
No, I mean, what I've seen is people trying to base action, raise claims based on the Hobby Lobby decision and being turned away because they tried to bring the lawsuit themselves in disregard of the Tax Anti-Injunction Act or something like that. But certainly you'd have to go through the administrative process at the IRS, which is not going to recognize this defense, and you would lose in the administrative process, and you'd have to be persistent and keep appealing until you get to the stage where the case could be in court, and then you'd hope to be lucky and get a sympathetic, open-minded judge that would apply these principles. But I haven't seen these brand new decisions that just from the last few months being applied to in other contexts. It's too soon to see that.
Rick?
I mean, when you see a case being decided, you're seeing it on appeal ordinarily, meaning a year or two after the case was initiated.
Right.
So Peter,
Rick Yoder?
yeah, if I understand you right, what this would take, I mean, all of us who do some form of resistance to paying taxes, we all get letters from the IRS with different levels of threat, and ultimately putting a lien on our bank accounts or taking from our bank accounts, taking from our state returns. What you're saying is it would take one of us to challenge that.
Yeah.
All the way from, well, all the way up from where we start to the top. Am I hearing you right?
Well, you don't have to, whether you go all the way up depends on whether you win at lower.
Yes.
You know,
But
the federal court system has, well, there are two ways the tax cases go to court. There are a variety of ways the tax cases wind up in court. If you say you owe a certain amount of money and the IRS disagrees with you, that's the kind of challenge, and you challenge it, that winds up in an administrative court called the tax court, and it doesn't get into the regular neutral federal courts until it's at the appellate level. If money is collected from you and you say it shouldn't have been collected and you want it back and the IRS disagrees, you can actually sue for a refund in the district court. So it might be that kind of case. The money has to have been collected first. So it might be a refund action in the district court. And then it also might be a challenge, as I suggested. If I were playing strategist, and wanting to advance this issue in a new way, I would start with a penalty case. I wouldn't start with resistance to paying the taxes. I would just say that a resistor from whom taxes are collected involuntarily, as you suggest, Rick, from a bank account or something like that, would object to the addition of penalties for lateness or something like that, saying that the lateness or the underpayment or whatever was being penalized resulted from a sincere exercise of religious belief, and therefore the penalty should be neutralized. The penalty should be vacated, and you would wind up even, paying only the amount that the tax law says that you should pay, and having paid it involuntarily rather than voluntarily, but at no cost to you. That would be equal treatment. And that would be none of these cases are easy, but that would be the easiest case. And it would be the one I would want to do first to establish a precedent. The frivolous filing penalty, depending on how it's applied to a given person, would create the possibility for that as well.
So let me just continue. Let's say somebody in this group or anybody took that route and said, made the appeal to get the penalty returned. Be more specific on how we might do that. And we would obviously couldn't do it alone. We would need sort of legal assistance from someone like yourself.
Yeah, it would be foolish to bring a court case without a lawyer.
Yeah.
It can be done legally, but it almost never, you would get tripped up on some procedural thing and you wind up not making your point correctly. So somebody, let's say it was someone in Lancaster that had taxes collected from them involuntarily, and the amount that was collected was larger than the base amount of tax. Let's put aside interest for right now, because interest compensates only for lateness. That would be a little bit of the use of the money. That would be a slightly harder argument to make than penalties. But even so, if the lateness results from religious belief, you could make the same argument against even the addition of interest. But let's say it was collected with a penalty, the 5% penalty for failure to file, or the 1% per month penalty for lateness of paying, the 25% payment penalty for gross understatement of income, or even in the rare case, the 75% penalty for fraud, and that money was collected, you would then ask the IRS for a refund with assistance. You would ask for the IRS for a refund. They'd refuse the refund. of the amount collected, and you could bring a lawsuit in the federal district court for the Eastern District of Pennsylvania, which encompasses Lancaster County, seeking a refund and making this argument as your grounds for refund. And it would be randomly assigned to one of the 20 federal judges that sit in Philadelphia, Lancaster, and York, and Wilkes-Barre, and Allentown, and other places around the Eastern District of Pennsylvania. Sorry, not Wilkes-Barre, that's the Middle District. And that judge would rule. My recollection is there's no right to a jury trial in those cases. I think it's a judge trial. And if the judge ruled against you, you'd have a right of appeal to the Federal Appeals Court that sits in Philadelphia, called the U.S. Court of Appeals for the Third Circuit. It's the court where I do most of my work. And if they ruled against you, then to the Supreme Court. Was that more than you wanted to know, or
No, that's
missed the
exactly.
point of your question?
That's exactly what we want practical stuff here if we decide to move forward with this.
Sure. Did Lincoln, you want to footnote something I said,
or a separate question? Just curious about your thoughts on, something that has happened to a few folks in our network is for a few of the folks who have a seriously delinquent tax debt, which means their tax debt is greater than $54,000 currently, they've received notice from the IRS that the IRS contacted the State Department that they cannot renew or obtain a passport. There have been a couple separate non-WTR cases where people have brought this to a circuit court and said that this law infringed on their right, to travel. In those cases, those circuit court justices have stated they only have a constitutional right to travel within the United States and not one to travel abroad. So, there's a bunch of stuff happening with that, but I was curious, does war tax resistance, if one of them was a war tax resistor and it was based on religious grounds, do you think that would change the case at all, or is that a possibility?
Yes, I do. Because in fact, the right to international travel against passport revocation was upheld in the 1950s when the government was revoking people's passports for communist sympathies or party membership. So saying, well, the Constitution only protects the right to interstate travel, not international travel, is not true when the reason for denying travel is in the First Amendment realm. So adding the religion component to it actually would absolutely make it a different case.
Other questions?
Harold,
Yes.
is this audible? I'm not always sure with this computer where it's going.
A little faint, but I can hear you just about.
Okay. This is David Ortman out here in Seattle. Very briefly,
David.
Very thanks for participating in this. Very briefly, Washington is one of the few states that lets you take the bar exam without going to law school. Requires a law clerk program, which I entered, and in the process of applying, they asked you for everything you've done, including parking tickets and not feeding your cat. So I put down the fact that for about 30 years, we have not been paying the federal excise tax on the phone bill. And occasionally, depending on the 1040 forms that we're using, have withheld money as well and been collected on. So nothing really came of that. And 4 years later, I went and applied to take the bar examination, which has the same forms about parking tickets and not feeding your cat. And once again, disclosed that I had been withholding the phone tax and occasionally income tax. Took the bar exam course. I was preparing to take the bar exam when about 2 weeks prior to this, I received a letter from the disciplinary committee of the Bar Association here in Washington, asking me to come in for a meeting as to whether I was fit to take the bar in the first place. So after ignoring the fact that I had disclosed all this, they decided at the very last minute that they were going to haul me in for a meeting to determine whether I could actually take the bar in the first place. So I had to go hire an attorney in order to take the bar. And in essence, the argument that we presented was a little more nuanced in the sense that I said when I had to declare that I was a conscientious objector back during my draft days after they denied my application the first time and had to go before the draft board to get my CO status. I said that in order to declare myself to be a conscientious objector, the definition required that it wasn't good enough to be just against the Vietnam War at the time, and it wasn't good enough to be against all war at any time. The definition said you had to be against all war in any form. And I said that represented a conflict of laws because paying for war was, in essence, the very basis of the definition of being a conscientious objector. And they mulled that over, and about a week before the bar exam took place, I got the letter saying, well, okay, go ahead, but behave yourself. So that was the essence of that. But I'm curious whether the more nuanced argument that in effect, by claiming to be a conscious objector, you have to comply with all the components of it, including the fact that you had to be against all war in any form, including paying for it, might be an avenue to overcome the Hobby Lobby thing, which is a little different in its dismissal of religious freedom for conscientious objectors. If that made any sense, sorry.
I actually don't know what your question is,
Okay. Well,
but I'm glad they let you take the bar exam.
well, the question is, can you bring a case that is a little more nuanced by saying that you're basing your claim for war resistance on the fact that the conscientious objector definition requires you to not pay taxes because it's a form?
I don't really understand the argument, but we could talk about it separately later. I mean, the fact that there's an objection to one government program doesn't require that the exemption be the same from another program. The focus of these decisions is on what the government program and interest is. The interest on collecting taxes is not the same as the interest in raising an army. So it wouldn't necessarily be the same. I don't see it, but that's just my opinion.
Peter, a number of us are concerned about the fact that the Religious Freedom Peace Tax Fund legislation in the Congress has just basically gone nowhere over the last number of years, for a long time. And you know, I think the issue is raised, well, why not, instead of taking the legislative route, why not take the legal route? And I think a number of us war tax resistors are frustrated by the fact that we just can't seem to find the wherewithal or the means to accomplish what we're trying to say.
My feeling about the Religious Peace Tax Fund is, if the principle that if the system that it describes would actually work, and it seems to me it's good reason to think it would, then the fact that you are offering to participate in such a system gives you the right already under the Religious Freedom Restoration Act, that in effect, the RFRA honestly applied gives you the benefit of the Peace Tax Fund without the Peace Tax Fund being separately enacted. That was part of what I said in Earlham. You know, if the government has to accommodate every religious objection to every government program, if it can do so without fatally impairing the functioning of the program, raising taxes in this case being the program, right? Then it has to do so. That's what RFRA says. So Peace Tax Fund is not pointless. It's proof that the tax system can function with a conscientious objector provision for religious objectors. That's the way I view it. And getting a special benefit for tax resistors, which is what the Religious Freedom Peace Tax Fund does, is less likely to pass Congress than an even-handed protection for all religious objectors to whatever program, which is what passed in RFRA. So,
Comments or
and it's a
questions?
matter of enforcing that right. Either that right or the free exercise right as redefined by the Supreme Court recently. So yeah, I mean, the Religious Peace Tax Fund campaign was as always as much a propaganda campaign for organizing and educating as it was an attempt to actually enact legislation, don't you think?
Well, it would have been wonderful. When I was on the board, it would have been wonderful if the legislation would have been enacted.
Well, I don't disagree with that, but
uh,
I'm just saying failing to get it enacted is also valuable if you keep talking about it and using it as a way of educating.
Is that should we be throwing more effort at that than trying to go through the legal system?
No, I think they work hand in hand.
So we continue.
I've always thought the campaign, the campaign is only that particular solution is only satisfactory to a certain number or percentage of war tax resistors. But for those that it would satisfy, it's very important. So it's a valuable piece of the larger picture. Everybody does what they need to do in their own way. People who want to pursue a legislative solution, great. And the availability of a legislative solution becomes a valuable argument for a constitutional court challenge or a RFRA challenge if it could be done, if the court would open its mind to what's really possible. I mean, if the Supreme Court says it's not possible to administer a tax program with a conscientious objector provision, and they just say that without any evidence behind it, maybe if evidence was presented that it was possible, a judge would change their mind. I don't know. They haven't, since it's their favorite thing to say without evidence, but maybe the Peace Tax Fund presents the evidence that it's not impossible.
I have a question, John Stoner here.
Hi, John.
A question about how good or possible a frivolous case would be to go forward. It's practically have war tax resistors been assessed a frivolous penalty? Has that happened to any yet?
Well, the IRS threatens the frivolous return penalty.
I've been threatened.
Yeah, and they have kind of two levels of threat. They have a sort of a vague, misleading threat, and then there's the serious threat. It's in a different form letter. But most people who are tax resistors file honest returns, and if you file an honest return, you're not eligible for the frivolous return penalty. Yeah. Filing an honest return and then refusing to pay all or part of the tax for conscientious reasons doesn't meet the definition of a frivolous return under the law. So this is what H.A. and his wife went through recently. They were threatened quite seriously with the penalty for their way of filing a tax return, which was paying all but $10.40 of the tax. And how long did it take, H.A.? It was over a year that we were fighting with them.
A year and a half, at least.
Year and a half, yeah. But then they, in their own way, admitted we were right and they withdrew the threat. So we didn't have to go to court. I wrote a 2-page letter for H.A. and his wife to sign and send, explaining why the penalty didn't apply to them.
Right.
In a nice way, and asking them to just correct this silly mistake they had made of threatening the penalty.
Yeah.
Not getting up on a high horse about it, just trying to be calm and reasonable. And they eventually, a year and a half later, sent a letter saying, never mind, you don't owe the penalty. They didn't admit they were wrong or apologize or anything, but
yeah, right, of course not.
They did sort of apologize, didn't they, in their own way? And a half-hearted apology.
I guess so.
Yeah. For the IRS, counted as an
Not
apology.
bad, not bad.
Yeah. But I don't know, Lincoln, has anybody actually failed to get an inappropriate penalty withdrawn?
Yeah, since the issue kind of came to a head probably close to 10 years ago, when there was the kind of their quality control person at the IRS that looked at this penalty said, oh yes, war tax resistors just for sending a letter should not have this penalty applied. Though there have been a couple of people like HA who have received this serious threat, on being alerted about how it was being misapplied, they've always pulled back on it. So, and even going back to the cases 10 years ago, after they realized their mistake, for those that they had taken money from, they refunded that $5,000. So since then, especially since 10 years ago, there's been no one that they've gone so far as to take the money from.
Even I didn't know that. That's a valuable piece of information from this session this morning. Thank you very much. I would like to share that there's some people on this session who have withheld all of what they owed to the IRS. That they discerned went to the military to taxes. To this point, the IRS hasn't responded to that, to the best of my knowledge. But what can we anticipate when it does, and when it says we get the letter back saying you withheld everything that was you thought went to war. You owe that. How do we respond, and what's our next steps?
I don't think you can do anything unless and until they collect it.
So there we are.
Right, or you could appeal it to the tax court and try to make this argument in tax court before it's collected. Those are the two avenues, but it has to be on the, as I've always said, on the defense. Another possibility is well, I don't know how it would be enforced, but I've pointed out that, remember, if you read your tax form carefully, there is, I think, a checkoff on the return that says I do or do not want $3 of my taxes to be sent to the presidential election campaign fund. So I've always interpreted that as meaning, well, they can redirect the taxes you pay to a program or away from a program that you choose to support or not to support. And if they can do that, then they have to do it for religious tax objection on the grounds of equal treatment. I mean, if religion is required to be treated at least as well as any remotely comparable secular objection, then these Supreme Court decisions I talked about from this year would suggest that there's a right to direct your full payment away from military spending.
Thank you, Peter, for that point about
I have no idea.
Can I ask one more question? I'm sorry.
Thank you for that point about redirecting money to the peace to the presidential election. That's a powerful point to make.
Rick Yoder has a question.
Yeah, I'm just trying to think of a step-by-step process that we would need to go through if someone decide to. So if someone files a lawsuit to get the refund or to have the penalty refunded, I'm thinking, okay, we would need to hire a lawyer who would agree to take this case. We would need to raise funds to pay the lawyer. Give us those steps in case somebody would decide. Let's get practical.
Well, it depends. First of all, I mean, how much the lawyer charges is up to the lawyer and you to agree. I mean, you might have a lawyer that doesn't charge you. Who knows, right? I mean, that
Sure.
All the good lawyers I know do a certain amount of pro bono work according to their own lights, whatever it may be. In my criminal appeals practice, I represent criminals with money and and I represent people without money, and the people without money, I may be appointed by the court, or I may just decide to do the case because I want to. You just need to meticulously follow the procedural steps that are applied to any tax case of the sort that you're in. You follow the same steps. So just as if the IRS had miscalculated your taxes and somehow gotten to the point of collecting them and you wanted a refund, you would follow the refund procedures. File, if the money was collected, and then if the refund is denied administratively, you file a lawsuit in the federal district court seeking the refund.
And Peter,
as an example of that, and however you would challenge a penalty that was collected. And if you disagree with the calculation of the tax that's due, you can, and you follow the procedures correctly for challenging the assessment, you can wind up in tax court with a trial before a tax court judge. And if you don't agree with the outcome, an appeal to the Federal Court of Appeals. The procedures are different for each scenario, and you need someone that knows tax procedure to guide you through it.
Is that helpful, Rick?
Yeah.
I mean,
Yeah.
you described me as a tax lawyer at one point, HA, and I'm not a tax lawyer. I just know tax procedure, but I don't know what's taxable and what's not taxable, and how you can arrange your financial affairs to owe less taxes, and that's what tax lawyers do.
My apologies for that oversight or mistake. Sorry about that, but
I can't help you prepare your tax return to minimize the amount of tax you owe. I hire someone else to do that for me.
Okay, I appreciate all that you do. I'm aware also of the fact that we only have about 2 minutes left in this session. And if there are other burning questions, we'll try and pursue them within the next 2 minutes. If not, we'll conclude the.
One last wonderful question.
Looks like you did a great job. I would like to suggest, though, in HA, we are going to put this on the website so you can encourage other people to watch. And if there are other questions, John, maybe we can work on something on a blog post or something that people can be responding to, and keep the conversation going.
Certainly, if we're picking and choosing a case to be a test case, I'd like somebody with a long history of sincere religious belief that can't really be questioned.
Yep.
Who knows? That may be one of us.
Could be.
Thank you so much, Peter, for being with us today. I mean, this is just a rich experience that I look forward to for a long time. We appreciate the relationship that 1040 for Peace and all of us and Newtrek that we have to work together on these very important issues of conscientious objection and religious freedom. It's very important stuff, and we're grateful for the relationships that we have to work at this. Thank you, Peter, for your input today. Blessings as we go forward. Take care, and may peace go with us.
Thank you all for being here.
Thank you.
Bye-bye.
Bye now.